that you needed an interpreter today.
Yes, Your Honor, I believe it. That's what happened.
All right, if English is not your native language, you have a right to an interpreter services. You understand that?
Yes.
Are you requesting Carlos's assistance for this hearing?
I am not.
All right. I want to make sure we get through this first, Carlos, before I let you go. All right, this is State of Kansas versus Oscar Bocanegra, case number 2025 CR 381. The defendant appears at the jail Zoom location. Jared Regier appears as prosecuting attorney. Mr. Bocanegra, do you have the charging document before you?
I do not, Your Honor.
Then I will advise you in count one, you have a charge pending in this court of criminal possession of a firearm by a convicted felon, a level 8 non-person felony. Count two, possession of a firearm under the influence, a class A non-person misdemeanor. Since a felony is involved, you will not be asked to plead today. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket is October 20, 2025 at 2:30 p.m. You must fully participate in Judge Satterfield's docket at that time, October 20th at 2:30 p.m. Mr. Bocanegra, have you heard and understood everything that the court has said so far?
Yes, Your Honor.
All right. Can you afford to hire your own lawyer?
Yes, Your Honor.
Okay. What kind of income do you have that you think you can do that?
I am self-employed. I have my own business.
What is your business?
Automotive
Welcome
repair.
back to another intense day in the courtroom. Today, we've got a case out of Kansas that's already raising eyebrows. The defendant, Oscar Bocanegra, is facing serious charges: criminal possession of a firearm by a convicted felon and possession of a firearm while under the influence. That's not a minor slip-up. That's a combination that can land someone years behind bars. And here's the kicker. The state claims he was intoxicated when he showed up at a property tied to his girlfriend's family, allegedly with a gun in hand. Now, imagine the tension in that room. Family ties, firearms, and prior convictions. The judge is about to lay out the charges and the stakes. Stick around, because what unfolds next is a fascinating clash between legal strategy, family drama, and one man's fight to avoid strict conditions that could change his everyday life.
Automotive repair.
Okay.
316 auto and diesel repair.
And where is that located?
Wichita, Kansas.
Okay. And you are confident, as you are before the court today, that you do have the financial resources available to you to pay a lawyer to represent you in a felony case?
Yes, Your Honor.
And this could be several thousands of dollars for an upfront retainer. Do you understand that?
Yes, Your Honor.
All right. You certainly have a right to hire your own lawyer. I'm going to resolve that doubt in your favor today, Mr. Bocanegra, and expect that you will have an attorney on board at your next court appearance before Judge Satterfield. All right. What bond is recommended here, Mr. Regier?
Your Honor, besides all standard conditions, the state is prepared to recommend a $3,000 cash or surety bond if the court will further order SCRAM and GPS monitoring. The affidavit in this matter does appear to refer to a specific location in Andover, Butler County, Kansas. The state understands that there is a pre-existing relationship between the defendant and the occupant of the property, so the state is requesting GPS monitoring as well as no contact with the occupants of the property. It would appear that, pursuant to the affidavit, that the defendant was observed as being visibly intoxicated, so that is the basis of the state's recommendation for SCRAM monitoring. Additionally, besides a strict prohibition against possessing firearms during the possession of this case, the state understands this is a defendant with a quite significant history of prior convictions from the state's perspective, at least one prior felony conviction for criminal possession of a firearm, approaching 10 felony and misdemeanor drug related convictions, as well as at least one prior adjudication for a felony drug related offense.
Gary, you made some references to a certain location and perhaps leaving certain locations or people alone. That doesn't appear to be contemplated by your charging document. So what is that all about?
Your Honor,
Okay, just a minute, Oscar. We'll get back to you. Mr. Regier?
Your Honor, the page 1 of the affidavit appears to refer to the location, as well as that the defendant approached the property while in possession of a firearm. States further information is that there is a pre-existing relationship based off additional reports.
All right. Certainly the suggestion by the charging document in this case would indicate that this court ordering Scram to be part of the bond requirements in this case makes sense, and the court will make that order. The court will set bond at $3,000 cash or professional surety required. Mr. Bocanegra, one condition of that bond is that at all times you have a Scram device on your person to monitor alcohol usage. You are not to drink alcohol as a condition of your bond. And then that Scram device will monitor that and report on it if necessary. As far as GPS is concerned, I still don't quite understand why GPS is required. He apparently is a well-established businessman in Wichita. So what would the state's concern be that would require GPS?
Your Honor, the state's primary concern is that going off the affidavit, the defendant approached the property in the middle of the night, shortly thereafter midnight, while in possession.
The property. What's the property?
Your Honor, the affidavit appears to refer to a specific address in Andover, Butler County, Kansas.
And he had some relationship with an individual there, and he doesn't live there. And that's a problem when he comes around those premises. Is that the state's theory here?
That would be the state's theory, Your Honor.
Mr. Bocanegra, do you have business in Butler County generally?
yes, Your Honor, I am there at least every day or every other day. My girlfriend and our daughter reside. She has her own house, but this is her mother's house, my mother-in-law's house, with the property that they are talking about. So we spend a lot of time over there. We go there at least every other day for dinner, or I go there and just visit with my daughter when I'm not working after work, and which I'm there at least 4 or 5 times a week. And sometimes I do stay the night there, no more than 3 nights, since I gotta be at home for my business. So sometimes I'll stay there at night. It gets too late at night. I don't want to drive home. I get up early in the morning, go open up shop. But yes, I do have a lot of business going on there at that property, since our daughter's there and so is my girlfriend. It's my mother-in-law's house.
All right. Mr. Regier, you're trying to keep him from going to the place he claims he goes multiple times a week?
That would be the state's recommendation based off the facts of this case, Your Honor.
Okay. All right. Well, I'll just tell you what I have before me, Mr. Regier. He's being charged with...
Now here's where things get really interesting. The state isn't just asking for a cash bond. They want GPS monitoring to track Oscar's movements, and even a no-contact order to keep him away from his girlfriend's mother's house. But listen closely. Oscar explains that this isn't just any property. His girlfriend and daughter live there, and he's over at that house several times a week for family dinners, childcare, and even overnight stays. So here's the dilemma. Should the court treat this as a safety risk, or as a man simply visiting his family? The judge seems skeptical about GPS, questioning whether it's fair to block someone from the very home where his child lives. This is where law and life collide. How do you balance public safety against personal family rights? What do you think? Should the judge side with the state's safety concerns or with Oscar's family ties? Drop your thoughts in the comments
He's being
below.
charged with criminally possessing a firearm as a convicted felon. So he's not supposed to have a firearm, and the state is accusing him of having one, and that he possessed it under the influence. It doesn't suggest a restraining order is necessary. Nor have you identified a person or a specific place he has to stay away from. I mean, was there some sort of altercation here?
One moment, Your Honor. Your Honor, the state's information is that prior to the incident, there had been certain communications between the occupants of the residence, which appear to be identified as the last two individuals on the endorsed witness list of the information. And it would appear based on that conversation, subsequently, the defendant approached the property with the firearm, is what is alleged based off the state's information.
Court's going to decline the state's request for a GPS system monitor on this defendant. And I'm not going to place any no contact or communication restrictions on you at this time, Mr. Bocanegra. I think the information before the court simply doesn't support it. But with that said, Mr. Bocanegra, if you're not wanted somewhere, don't be there. Somebody tells you they don't want to have contact, communication, or your presence on the property, you better heed that warning. Okay?
Understood, Your Honor.
Just stay separate from the situation, and maybe you want to consider doing that anyway till things settle down. All right? But the SCRAM device requirement does remain, and not to be drinking and to be monitored by SCRAM as a condition of the bond set at $3,000, cash or professional surety required. And he's going to get his own attorney to appear with him in court October 20th, 2:30 p.m. with Judge Satterfield. If there's nothing further, the Bocanegra case will currently be in recess. We'll move on to another matter. I don't think I have any other cases where I'm going to need an English-Spanish interpreter on the docket. Someone speak up, either at the jail or a prosecutor's office, if that isn't the case. Carlos, thank you for your
And
appearance
there
here
you
today.
have it. The judge ultimately sets bond at $3,000 with a SCRAM alcohol monitoring device, but rejects the prosecution's push for GPS and no contact restrictions. In plain English, that means Oscar can still see his family, but he'll be under strict monitoring to ensure he isn't drinking while this case moves forward. This ruling highlights how judges often weigh real-world consequences, like a father's relationship with his child, against the legal risks posed by repeat offenses. It's a fine balance of justice and
Thank you
compassion.
for your appearance here today. And I
Welcome, Your Honor. Anything else for your interpreter?
Nothing else. I can go ahead and release you at this time.
All right. Thank you very much and have a good weekend.
Okay, you too. Thank you again. Are you Josie Ryan?
No, Your Honor. This is Jonathan Mays. I believe that's the DOC inmate.
Okay.
Hey, Mom. Yeah, Josie Ryan.
See, I have EDCF on here.
Yes, sir.
And at the EDCF Zoom location, I have Josie Ryan.
Yes, sir.
Okay, speak
Yes,
up where
sir.
I can hear you.
Yes, sir.
Okay, thank you. That's better. I just want to make sure we can communicate, okay?
All right.
This is State of Kansas versus Josie J. Ryan. Local case number is 2025 MR 123. I'll note Jared Regere's appearance for the Butler County Attorney's Office. And Mr. Ryan, I have some information before me which suggests that the 16th Judicial Circuit, Jackson County, Missouri, has made a demand for your surrender regarding possession of a controlled substance except 35 grams or less of marijuana in violation, allegedly, of Missouri law. Also, tampering with a motor vehicle, first offense, and resisting, interfering with arrest, detention, or stop.
Yes.
I'm going to presuppose to a certain extent you already know the incident that these charges intend to address. You do have the right to procure legal counsel in this state and to seek a writ of habeas corpus in regards to this matter. Or instead of fighting extradition, you could agree to return to the state of Missouri by signing a waiver of extradition.
Yeah, I'm gonna sign the waiver.
Okay. You sure that's what you want to do?
Yes, sir.
All right. Does EDCF happen to have a waiver of extradition form to place before him?
Right here.
Yes, sir. Mr. Ryan, have you had an opportunity to read it?
Yes, sir.
Do you fully understand its contents?
Yes, sir.
If it is your intention to return to the state of Missouri without any further fight and face whatever it is you face there, you can go ahead and execute that at this time. All right. I can't really, okay, I see it. It appears that he has signed it. Can the officer in the room confirm that?
Yes, sir. He has signed it.
Thank you. All right, Mr. Ryan, you're apparently on a local DOC hold. When that's released, there will be arrangements made to transfer your custody to Jackson County, Missouri.
Yes,
I don't know exactly what the time frame will be on that, but generally there's great interagency cooperation, and you should be transferred immediately when you're eligible to be transferred. All right?
All right.
All right. Mr. Ryan, any questions?
No, sir.
All right. The local case will need to have a copy of that waiver of extradition in it. So if EDCF can make sure that our clerk's office receives that.
Yes, sir.
Thank you. Greatly appreciate it.
And it will also require your signature, I believe, sir.
Yes, it will.
All right. Just forward this to the clerk's office, or do you have an individual clerk you'd like us to use?
You can just send that to the clerk of the district court's office in Butler County.
Okay. Will
All
do.
right.
Thank you, sir.
All right. The Josie Ryan matter will be in recess. All right. Jonathan Mays? Okay.
Yes, Your Honor.
All right. This is State of Kansas versus Jonathan Lee Mays. Case number 2025 CR 179. Jared Regier appears for the state. Mr. Mays appears from the jail Zoom location. Now I see a bench warrant bond forfeiture order from Judge Webster's court. Docket notes would indicate that you are supposed to appear before that court on June the 30th. Court entered in order bond forfeiture bench warrant, $3,000 cash or surety ordered. You apparently were picked up on that and you haven't bonded back out. Right, Mr. Mays?
Yes, Your Honor.
Okay. Your case will be reset, since this is a Darren Patterson appointed case, to November 10, 2025, 8 o'clock a.m. You must fully participate in that docket at that time. If you do make bond, you will need to appear at the Butler County Judicial Center in El Dorado, Kansas, and no other location. Participate from there and there only. November 10th, 8 o'clock a.m. All right, Mr. Mays, do you have other holds on you?
No, I don't, Your Honor. I was actually in here. I missed court June 30th. Yes. I was actually in Lyon County Correctional Facility at the time. And so I was then brought back here and brought before the court on one of the charges, I guess, that I had been bonded out on May 30th, but not the other. So then I bonded out of, or got out of Butler County on August 12th, but this was issued August 11th. I'm just totally confused on this, why it's just now coming around. But I know I still got to take care of everything. I'm sorry. I thought I was going to court on Monday for this also.
Okay.
And I go to court on the 25th for the other stuff that was going on. So I'm just...
Is the other case a felony case?
No.
Okay, I don't know what your other case is.
And Your Honor, if I may.
You may.
Your Honor, the state understands there is another Butler County case involving the same defendant, 25 TR 187. It would appear a bond has been executed in that matter for a $2,000 professional surety for an appearance on October 20th at 8 a.m.
All right. Well, it makes sense to go ahead and set this case along with the other one. So the court will re-announce his next appearance date in this current 179 case for October 20th at 8 o'clock a.m. Defendant must appear fully on Judge Webster's docket at that time, October 20th, 8 o'clock a.m. Do we have any information confirming that he was in jail on June 30th?
There
when
should
he
be
was supposed to have been here?
I'm sorry, there should be a letter in my file that they read last time where I wrote to the court, the district clerk, to let her know what was going on.
State has no knowledge as to that at this time, Your Honor.
Court always wonders about the propriety of that excuse that I was locked up in another jail and I couldn't appear in your court. Not a real great reason. Mr. Mays?
No, I understand that it's not a great reason. That's where I was. Last time they just reinstated my bond and the bonding agency was able to come sign me back out. I was just
the same one, second chance?
Yes, it was.
This letter that you were referring to is not part of this file, from what I can see.
It must still be on the CR 179 or the 187, whichever. I'm sorry.
Mr. Mays, you need to quit getting so many cases.
Oh, I know. I'm set up. I've got a bed date to go to rehab right now. I've already met with SAC. I've met with Ryan Smith, the city probation officer on Monday, and we didn't know this was out there.
Where do you generally reside at, Mr. Mays?
Right now, I am technically homeless. That's why I'm going to rehab also.
And
Right.
how
This
do you know
next
that?
segment features several defendants, each at a different crossroads in life. First up, we've got Mr. Mace, who openly admits he's homeless and battling substance use. What stands out? He's already lined up a rehab bed, but only if he can stay out long enough to take it. The judge has to weigh, is this a man finally turning his life around, or just making promises the court has heard before? From homelessness and drug addiction, to probation violations and repeated failures to appear, these cases highlight the ongoing struggle courts face when balancing second chances with accountability. Let's dive in.
And
Right.
how do you know
I've
that you
been
have a
staying-
rehab bed?
Because I've already met with SAC here in El Dorado, and they just let me know that there's a bed date, and they've got me set up for
Okay, when's the bed date?
it. Basically, as soon as I get out.
I see.
I was staying with my mom while I was waiting for that to happen. I've been going down to SAC every day.
You do realize that in Kansas, you can't possess or use marijuana, don't you?
Oh, absolutely. I can't be using it anyways. I just found out I've got a mental condition also, so it messes me up even worse. I understand I've just been doing nothing but messing up, but I do want to change that.
A lot of people say it, but only a few people do it.
I understand that.
I'm going to give you a chance here, Mr. Mays. I'm going to reset your bond in this case at $1,500 cash or professional surety. If second chance will stay on this bond, I'll go ahead and place you back on it.
Okay.
If you have a bed date, though, keep it.
Oh, absolutely.
And you
My
do
biggest
understand
priority.
that you have a dual case court date.
Yes.
for
Yes.
October 20th at 8:00 a.m. and that you have to appear at the Judicial Center in El Dorado and nowhere
Absolutely.
else.
Yeah, absolutely. I've got a 16-year-old son that I've already missed 4+ months of time with, and I'm going to do everything I can not to miss any more time with him.
Okay. Well, today I'm going to believe you. We'll see what you end up doing in actual action in this case.
Absolutely.
Mr. Mays.
I appreciate you.
Bond $1,500 reinstated. Again, I can't speak for your surety, but if your surety wants to stay on the bond, then court's all right with that.
Okay. Thank you, Your Honor. I
Don't forget
appreciate
that court
letting
date,
me know.
Mr. Mays.
Absolutely. October 20th.
Yeah, and don't get your stuff locked up somewhere else again so that you can't appear. Okay?
Absolutely.
All right. Real good, Mr. Mays. Anything else, Mr.
Thank
McGear?
From the state, Your Honor.
Very well. The Mays
Thank you
matter
very
is in recess at this time.
Thank you very much.
Cameron McSwain? Response? There's an individual at the detention center. I was just asking, are you Cameron McSwain? Okay, there's a nod, yes. Can you answer out loud? Or are we having audio problems here? I'm trusting that the detention center is going to try to log back in here momentarily.
I would assume so, Judge. There they are.
For the detention center Zoom, join with video.
Can you hear us, Your Honor?
I can. Cameron McSwain.
Yes, sir.
All right. Mr. McSwain, the information before the court is that you were picked up on suspicion of distribution of an opiate, possession of an opiate. At this point, the state has not filed charges against you. If you were to be released, where would you be residing?
Salina, Kansas.
Salina has addresses, right?
Yes, sir.
What would yours be?
617 Lena Avenue,
Okay.
Lena.
Okay. And who lives there besides you?
My aunt and uncle.
Okay. Does your aunt and uncle know that you would be returning to their residence?
Yeah.
And this would be for the foreseeable future that you would live there?
Yeah.
The reason why I ask you that is that the state, if they decide to file charges, are going to issue a summons and try to have that served at that address. And then that just gives you a court date to come back. That's the easy way. The hard
Yes,
way
sir.
is they have to issue an arrest warrant to drag you back into court, which wouldn't be good for you. So that's why I wanted to make sure that we had a good address for you. Okay?
Yes, sir.
Right, Mr. McSwain, as there are no pending charges, I'm going to go ahead and order you released at this time. Pending
Thank
further
you.
proceedings in the case if the prosecution decides to charge. All right? But I sure hope that's a good address.
Yes, sir.
All right.
Could you read it back to me?
Read what back to you?
The address?
617 Lena Avenue?
Yes, sir.
That's the one you gave me. You should know it, right?
Yeah.
Okay. All right. That's the one that I think that the county attorney's office will rely upon if they decide to issue a summons and file charges. All right?
Yes, sir.
Okay.
Thank you.
All right, Mr. McSwain. It'll take them a little while to get you processed out, but unless you have other holds, you'll be released today. Just make sure
Yes,
you
sir.
respond to any paperwork you get in the future regarding a court date. All right?
Thank you.
Very well. The McSwain matter will be in recess. We'll move on to another matter. Austin Bland.
Yes, Your Honor.
This is State of Kansas versus Austin Eugene Bland. It's case number 2025 CR 163. Austin Bland appears from the jail Zoom location. Jared Regier for the State of Kansas. Mr. Bland, it appears that there was an attempt to serve a summons upon you. There was a residential service. made by the sheriff's office in Sedgwick County, apparently, giving you an initial court date of June the 2nd. Notes from June 2nd indicate that you did not appear. A bench warrant was issued with a $4,500 cash or surety bond. You are facing charges of possession of an opiate, a level 5 drug felony in count 1, and count 2, possession of paraphernalia for use, a class B misdemeanor. Since felonies are involved, you'll not be asked to plead at this time. Rather, preliminary hearing scheduling will be made before this court, as I'm your assigned judge. This court's next docket for that purpose would be October 6, 2025 at 2:30 p.m. You must fully participate in that docket at that time. October 6, 2:30 p.m.
You have pen and paper?
Bond has been set at $4,500 cash or professional surety required. Mr. Bland, can you afford to hire your own lawyer?
No, you aren't.
Are you not working right now?
I currently am working.
What do you do?
I do a tree service. I work for A&E Tree Service. Cut down
Okay, how
trees.
much money do you make doing that job?
About $10 an hour.
Okay.
Well, my boss was just in jail recently, so we haven't been getting paid for a couple of weeks.
Oh, ooh. Rough stretch for you.
Yeah.
Okay. And you live in Wichita?
Yes, sir. Yes, Your Honor.
Hmm. How come you didn't appear in court when you were supposed to?
It was a bit hard trying to find a ride. You said it was on June 1st, right?
June 2nd.
June 2nd. Yeah, I was trying to find a ride the whole time.
Well, that's a Zoom docket. You could have appeared by Zoom.
I wasn't aware of that. How can I do that? Because I would have gotten that taken care of if I knew I could go to Zoom.
$10 an hour in a shaky payroll situation. The court's going to find the defendant indigent and will appoint a lawyer to represent him. James Watts will be appointed. And again, his court date is October 6, 2025, 2:30 p.m. in this court. How come you need a ride to get to court, Mr. Bland? You don't have a driver's license?
No, Your Honor.
Oh,
Or a vehicle of my own. I usually ride my bicycle.
okay. Long way from Wichita to El Dorado.
Yes, it is.
All right. Well, you can participate in the next docket by Zoom. All right, Mr. Bland, I think I'm going to give you a chance at a lower bond here. I don't know if you're going to be able to make this bond either.
This is one of those moments that shows just how fragile the system can be. Here's Austin Bland, charged with drug possession, who says he missed court not because he didn't care, but because he didn't know he could appear by Zoom, and because he literally relies on a bicycle to travel. It's a telling snapshot of how poverty, lack of transportation, and even digital illiteracy collide with the legal process. The judge does something unusual here. Instead of holding firm on the original $4,500 bond, he cuts it almost in half to $2,500 and explains in detail how Bland can log into Zoom next time. This isn't just about law, it's about accessibility. What do you think? Should the courts be more flexible with defendants who clearly struggle with basic resources? Or should personal responsibility still outweigh those hardships?
Well, I'm going to go ahead and reset your bond at $2,500 cash or surety, down from the $4,500 originally set.
Okay.
You just better appear by Zoom at the next court date that I gave you.
Yes, sir. Yes, Your Honor. How do I go about that exactly? Because I've never done Zoom before, so.
You can usually do it from a smartphone. Download the Zoom app.
Okay.
And put in the proper numbers. The other thing you can do is appear from your attorney's office, Mr. Watts.
Mm-hmm.
You can go to his office in El Dorado and appear from there, if that's a better option. And he can probably give you some assistance and instruction on how to participate by Zoom remotely. if that's what you need.
Okay.
Okay. The 2,500 cash or professional surety. Court date, October 6th, 2:30.
Like
James
2:30.
Watts appointed. Anything else we need to address on him, Mr. Regier?
Not from the state, Your Honor.
Okay. All right, Mr. Bland, I think that's all the business we have at this time. I hope
All right,
you're able
thank
to
you.
make that bond and show up for court like you're supposed to in the future.
Yes, sir.
All right.
Thank you.
Land matters in recess. All right. James Aaron Hensley.
Yes, sir.
All right, this is State of Kansas versus James Aaron Hensley. It's case number 2025 CR 203, with Jared Regier appearing for the state and Mr. Hensley from the jail Zoom location. I see docket notes from just 2 days ago. Defendant taken into custody over the noon hour. Bond forfeiture bench warrant to remain as a no bond hold due to some previous failure to appear in Judge Satterfield's court. It's already been reset to September 16th at 1 o'clock in person. And it says defendant appears on first appearance docket today. James Watts may motion Judge Satterfield's court for bond modification. I'm not sure why you're here, Mr. Hensley. Do you know why?
I was 2 hours late for court on Wednesday, sir.
Okay.
I guess that was unacceptable.
No, not to Judge Satterfield and certainly not to this court. So, but you've got another court date set for September the 16th, and under Judge Satterfield's current order, it appears you're on a no bond hold, so you're not going to get out. And I'm not going to disturb that order. Your attorney is Mr. Watts. So I'm not sure what business we have to conduct today. Mr. Regier, can you fill the gap?
One moment, Your Honor.
I mean, if you've already appeared before Judge Satterfield, she's left the no bond hold in place and set you a new court date. I'm not sure why you're on this docket in the same case.
Your Honor, I do not believe I have anything to add beyond what the court has already referred to. This is a case that appears to be filed by my colleague, Mr. Sweeney, and I was not present at the most recent hearing.
All right. And I don't see Mr. Watts on this meeting, so presumably he's not going to be making any oral motions for bond modification at this time, though he can do that later, Mr. Hensley.
Okay.
But you do have a court date not too far down the line, September 16th at 1 o'clock for an evidentiary hearing, apparently, in Judge Satterfield's court. And Mr. Watts remains your attorney. So I don't know if there's any other orders or business the court needs to conduct in your case. So at this time, Mr. Hensley, I think that'll conclude our business today, and we'll move on to another matter.
Okay.
Jack Giorgino,
Yes, Mr. Ricky.
Judge Ricky, or Your Honor would be fine.
I'm sorry. Yes, Your Honor.
This is State of Kansas versus Jack W. Giorgino. It's case number 2023 CR 210. Jared Regier appearing for the state, defendant appearing from the jail Zoom location. I have a warrant to show cause alleging probation violation in this case. Essentially, the defendant's case was under review by the state of Colorado for an interstate compact case on January 6, 2025.
And that wraps up a series of cases that show the spectrum of courtroom realities, from people trying to get into rehab, to those caught cycling in and out of probation, to others claiming simple misunderstandings kept them from appearing in court. In Lizzie Hudson's case, her request for inpatient treatment clashes with the fact she spent 3 months at large, never voluntarily entering rehab on her own. The judge, and all of us watching, are left questioning, is this genuine readiness to change or just another attempt to avoid the consequences? One thing's clear. Every defendant today faced a turning point, and every ruling carried a ripple effect beyond just the charges on paper.
2025, State of Colorado notified Ms. Stanfield from Community Corrections that they had confirmed and spoke with the defendant's parents, and he was not living with them, and they did not know where he was. So a warrant to show cause issued. This court has established bond at $50,000 cash for professional surety. Further hearing will need to be set on the allegation of the warrant to show cause. I can go ahead and establish a court date on that for September 12, 2025, 2:30 p.m. If you make your bond, you must appear at the Butler County Judicial Center in El Dorado, Kansas, and no other location. If you don't make the bond, obviously you'll participate by Zoom from the jail. And that is September 12th at 2:30. Can you afford an attorney?
No, Your Honor, I cannot.
I'm going to go ahead and appoint a lawyer to represent you.
I thought I was already appointed Joseph Favre.
Well, that was with the original case, yes.
What?
I will appoint James Watts. He can assign the case to Mr. Favre if he wants to. So you will have legal counsel one way or the other at your next hearing, either Mr. Watts or Mr. Favre.
Okay.
So counsel's been appointed. We've got a court date set, and bond has been previously established. Does the defendant have something else to address the court about?
I'm just trying to just get sentenced. I'm not trying to all I'm here on is that violation. This is my second violation. I don't want to get reinstated. That's for sure. I'm just trying to, I don't even know what my underline was, probation for a year. And if I were to violate that, I would get 6 months. I'm just trying to do the time that's, I don't want probation. I don't want any of that. This is my last case. I'm trying to get in the military. I'm, with I think this past time, I got sober and I've been staying sober. I'm just.
Okay. You're probably going further with this than you really should. I want you to have an opportunity to consult with legal counsel regarding this case. Perhaps your position won't change, but I want to make sure you understand what you're getting into. This is a prison sentence, not a jail sentence. You understand that? You'd go to a Department of Corrections facility, a prison. You do understand that, don't you?
Yes, Your Honor.
So we're going to go ahead and take this up again at the hearing where you have the advice and assistance of legal counsel.
Okay.
And I've set that date not too far down the line, September 12th at 2:30. And we'll address your case again at that time. All right.
Thank you, Your Honor.
Okay. If there's nothing further, then this matter will be in recess. And again, we'll move on to another matter. Leslie Hudson.
Yes, sir.
So State of Kansas versus Leslie Aaron Hudson. Case number 2023 CR 18. Jared Regier appearing for the State of Kansas. Leslie Hudson appearing from the jail Zoom location. Or does recall this matter. On May 16th, you had probably been previously ordered to appear at the courthouse, but the court did allow you to handle your probation violation case remotely. You stipulated to all the violations except possession of methamphetamine, fentanyl, and marijuana. The defendant was ordered by this court to appear by 3:45 at the Judicial Center. Court called the case at 4:15, a half hour beyond that time. Defendant did not appear, and the court ordered a bond forfeiture and a bench warrant with a no bond hold. Strangely, Ms. Hudson, you weren't picked up for 3 months, so obviously you didn't do anything to surrender yourself on this. Docket notes from August 20th indicate that it was set over to today's date with this court to address bond and other matters. Ms. Hudson, we are going to need to set another hearing on a warrant to show cause docket. That is September the 12th at 2:30.
May I request inpatient treatment?
You can request it.
I have not done inpatient rehab, and I feel like that could be something that would benefit me.
Well,
It
which
helped
begs
me.
the question that you've been out at large for 3 months after your probation hearing, and why didn't you put yourself in inpatient treatment?
I just thought it would have to be court ordered.
Well, we'll deal with that on September the 12th. For now, your no bond hold remains. I can't trust you to come to court on your own. So we're going to have you held on that hold till September 12th at 2:30.
where cases continue to unfold one after another. This next stretch begins with Lizzie Hudson, who remains in custody on a no-bond hold. Despite her request for treatment, the court isn't convinced she'll appear on her own, and her future now depends on a September hearing. From there, we move into cases involving criminal trespass, probation violations, unpaid fines, and repeat failures to appear. What ties them together? Each defendant is navigating not just charges, but also credibility, convincing the judge whether they deserve leniency or stricter control. Let's break it down.
2:30. James Watts remains as your attorney in this matter and will represent you at that hearing. So to recap, James Watts remains as Leslie Hudson's lawyer. She remains in jail on a no bond hold pending further hearing in her case, September 12th, 2025 at 2:30 p.m. All right, Mr. Regier, is there anything else from your perspective that we still need to address on Leslie Hudson?
More of a point of clarification, Your Honor. It would appear that at least some of the violations alleged in the request for revocation have been stipulated to already. Does the court wish my office to issue a subpoena for the necessary probation officer for the next setting?
Well, that'll be up to your office, but she has stipulated the violations. It was the dispositional part of the case that she was required to appear on, and that will be the matters that we address at our next court date.
Very good, Your Honor.
But I think it would be quite helpful to have the probation officer there at that next hearing. Who is your probation officer, Ms. Hudson?
Teresa Stanfield, sir.
Okay. I'm glad that you knew. Okay. Then I would want that community corrections officer or the appropriate community corrections officer there for the dispositional phase of this particular warrant to show cause. All right.
Yes,
If
sir.
there's nothing further, that should conclude our business on the Leslie Hudson matter at this time.
I believe that's all for the jail, Your Honor. I'm sorry for the technical issues there.
Well, we got it all worked out. Thank you for your assistance today.
Good one.
All right. I'm going to go ahead and take up David Wayne Heil at this time. I'm a little worried about losing his Zoom, and he's been patient to this point. Take up State of Kansas versus David Wayne Heil, case number 2025 CR 379. Again, Mr. Heil appears on his own Zoom. Jared Regier on behalf of the state. Mr. Heil, I trust you can hear me okay? Unmute yourself, please. No, I don't want your video to go away. I just want you to join us with audio.
Hello?
Mr. Heil?
Yeah. Can you hear me?
I can, but I can't see you now. So if you join...
I know. I'm sorry. I'm trying to... I don't know what happened.
Mr. Heil, I did see you earlier. you're facing a charge in our court of criminal trespass, a Class B misdemeanor, punishable by up to 6 months in the county jail and a $1,000 fine or both. You understand that?
Yes, sir.
What are your intentions regarding a plea today?
Not guilty.
Okay. Court will accept a plea of not guilty. Can you afford to hire your own lawyer, Mr. Heil?
I have to see if Joe Allen out of Ottawa County can represent me up down there.
Well, I want to make sure you have legal counsel available to you at your next setting. So, I mean, are you sure you have the financial resources to hire a lawyer?
Yes.
Okay. You're working then?
Pardon me?
You're working? You have a job?
Yes, I work for myself.
And what do you do?
Construction
Okay.
and landscaping.
Just make sure that you have an attorney on board when you appear for your next court date. That will be before Judge Webster. November 10, 2025 at 9:00 a.m. That's a Zoom docket. You must be present personally on that meeting along with your attorney. November the 10th at 9:00 a.m., Judge Webster Zoom court. You understand that, Mr. Heil?
November 10th at 9:00 a.m. Yes, sir.
Okay. I'm going to approve your current bond that's been placed before the court. It's a $1,000 surety bond with Butler County bail bonding. I'll maintain this defendant under it pending further proceedings in his case due to his appearance on this docket. So 1,000 Butler County bail bond is maintained. And Mr. Heil will hire his own lawyer and have that lawyer with him at his next court date. All right, Mr. Heil, I got your video back. It's good to see you.
Yeah, sorry about that. I don't know what happened.
Okay. You also might want to talk to your attorney about the proper way to dress for court.
That's proper way to what?
Dress for court.
Okay. Yeah, I've been outside working and I just zoomed in.
Okay,
So,
well, we're a conservative business environment here, Mr. Heil, so just keep that in mind.
yes, sir. And I apologize. Like I said, I've been working, so I just got right on Zoom.
I understand you're a working man, Mr. Heil. All right, so you have any questions about what we've done here, Mr. Heil?
Nope. November 10th at 9 a.m.
Yes, that's correct.
Okay.
And Mr. Regier, anything further?
Your Honor, the state does have an oral motion on the issue of bond conditions if the court will hear it.
Okay, what's your request?
Your Honor, the state is asking to add as an additional condition of bond that the defendant be ordered not to leave the state of Kansas during the pendency of this case. Besides the number of prior convictions, the state understands this is a defendant with at least 13 prior failures to appear, most recently in January of last year.
13 priors?
13 prior failures to appear, Your Honor. If I misspoke, I apologize.
No.
Over how long?
Well, doesn't matter how long it's over. That is a concern. Do you have to work out of state, Mr. Heil?
No, I don't plan on going out of state at all.
Okay. Well, I'm going to adopt the condition then that he can't leave the state of Kansas as a condition of bond.
Yep.
And I'm going to endorse it on the appearance bond. Very well then. That would appear to conclude the business on David Wayne Heil at this time. Mr. Heil, I can go ahead and release you at this time. You can get back to work.
Thank you, sir. You have a great weekend.
You too. Heil matters.
Here's a
in
striking example of how a defendant's past shapes their present. David Wayne. High faces a relatively minor trespass charge, but the state points out something major: 13 prior failures to appear. That history raises big questions about reliability. Even though High says he works in construction and can hire his own attorney, the judge tightens the leash, adding a condition that he can't leave Kansas while this case is pending. It's a reminder that in court, your record follows you. Do you think restrictions like these are fair safeguards against flight, or unfair punishments for someone just trying to work and move on?
Heil matters in recess. All right, I've got an individual at Court Security 1 that I wish to address. Who is that?
Gary Ingram Jr., sir.
Okay. Take up your case next. It's the state of Kansas versus Gary Orlando Ingram Jr., case number 2021, CR 319. Jared Regier appearing for the state. Gary Ingram Jr. appearing at the Court Security Zoom location at the Judicial Center. I see a bench warrant for failure to appear. This stems back to a court appearance that was ordered back on March 23 of 2022. Sort this out. This is a post-sentencing matter. Defendant appeared on October 18 of 2021. Pled no contest to count 1 and count 3. Count 1 being interference with law enforcement, a Class A misdemeanor. Count 3 appearing to be driving while habitual violator, a Class A misdemeanor. Mr. Ingram, is that what you pled to?
I believe so, something like that.
Yeah. So,
I thought it was something like driving without a license or something like that, or it got
okay, I'm
reduced to something.
just going on what the docket notes seem to suggest here. You had a 6 months jail sentence on count 1, 1 year probation. Count 3, $100 fine, 6 months in jail, concurrent. Pay or appear hearing December 20th of 2021 at 9 a.m. And then at that December 2021 date, you didn't appear.
Your Honor, I was in custody. I was released to another agency in McPherson. So after I was released for the pay or appear, McPherson kept me for a previous case before you guys. So I sat in there for 9 months because I was on parole. So I had exhausted my parole, which wasn't over until March 15th of 2021. I mean, not 21, 22. So then you guys brought me back after March and I came back to court again.
Mm-hmm.
Well, after that, I went back to prison. And ever since then, I've been in and out of custody. And from what I knew, the fines went to Butler and Associates, to collections. So I did not know that this matter was still existing because they didn't notify me in prison to tell me I had any kind of notification warrants or I had any kind of detainers. So I was never served anything. I didn't know.
How much do you still owe on your case here, Mr. Ingram? Do you know?
Sir, I think I owe like 300 and I think it's around 350, maybe no more than 375, I think.
Do you happen to have that number before you, Mr. Regier?
Your Honor, I have managed to review the case summary on the Pollard Portal Access website. There appears to be a balance due as of today's date in the amount of $358.00. The state's information is that there have never been any payments submitted towards this matter.
Okay, Mr. Ingram, you ran into some law enforcement officials in Sedgwick County recently.
Yes, sir, and I had to bond out on that.
There's a lot of scribbling here. You had the assistance of a surety bondsman?
Yes, I'm on bond right now.
Okay. Who's your bondsman?
I'm bonded out through Wichita Bonding.
Okay. Strangely, it doesn't say that on the bond. Let me see for some additional paperwork here. Okay. But obviously secured your appearance, Mr. Ingram. You did what you were supposed to do under the terms and conditions of your bond. All right, I'm going to inquire of the prosecuting attorney in this case. What do you want done with Mr. Ingram?
Your Honor, at this juncture, the state is requesting that this matter be sent to collections if it's not already in that procedural position. The 1 year non-reporting probation ordered at the time of sentencing in this matter appears to have long since elapsed. The state is not aware of any request for revocation filed with the court in this matter. So in the interests of economy and not burdening the Butler County taxpayers with another hearing set, the state is merely suggesting this matter should be sent to collections.
Judge, I show the case is in collections already.
Mr. Ingram, I don't think we have any other business we need to do.
Oh, well.
You did what you were supposed to do under your bond, and that was appear today. You do have a debt to the court that's just going to keep following you until you get it taken care of. I encourage you to do that as soon as you can.
Yes, sir.
It's now in the hands of a civil collection agency, and you'll work with them to get your case paid off from here on out.
Your Honor, I'm start work Monday. Once I get this money, can I just come to county clerk's office and pay that debt?
No, you're gonna have to follow the directions of the collection agency regarding your payments. Okay.
Yes, sir.
All right.
Yes, sir.
Which means you're going to owe a little more than the original debt, but that's what happens when there's a 4-year-old debt.
I understand that, Your Honor.
But the good news for you, Mr. Ingram, is you're not going to have any more court appearances.
That's a good thing.
Yes, it is. Yes,
It's
it is.
a long road, Your Honor.
It has been a long road. And the road's a little bit longer until you get this case taken care of, get it paid off, work with the collection agency, set up a payment plan. And then once you've paid off this debt, then you've truly got this entire thing behind you.
Yes, Your Honor. I really appreciate it.
You're released from any further obligations under your appearance bond at this time, Mr. Ingram. Just go to work and work on paying off this debt and others that you have, okay?
Yes, sir.
All right. Mr. Ingram, you're free to go.
Yes, sir. You guys have a good day.
You too.
Yes, sir.
Mr. Squire?
All right. James Patrick Squire.
Yes, Your Honor.
Okay. This is the State of Kansas versus James Patrick Squire, case number 2024 CR 491. Jared Regier appears for the state. Mr. Squire appears at the Judicial Center Zoom location. You're apparently here on a first appearance on a warrant to show cause alleging probation violation. You're on possession of drug paraphernalia. The allegations from Ms. Taronis, the CSO on this case, is that you failed to follow the law.
I'm sorry, go ahead.
Just wanted more detail on that. Picked up apparently in Butler County for charges of possession of methamphetamine, drug paraphernalia, driving while suspended, failure to register. Okay. That you failed to follow through with intensive outpatient treatment at 7th Direction, and you failed to pay your fines and court costs associated with the case. Further, hearing is need to be scheduled in regards to these allegations, and this would be before Judge Satterfield. Judge Satterfield's next docket for that purpose would be 2:30 p.m. on September the 19th, Mr. Squire.
Okay.
You are required to appear at the Butler County Judicial Center in El Dorado for that hearing and no other location in a similar way that you have appeared today. That's
Yes,
where
sir.
you need to appear next time.
Okay.
September 19, 2:30 p.m., Judge Satterfield's court. I do see a bond that apparently was ordered by Judge Satterfield in the amount of $5,000. This is a hot rod bail bond. Court will approve it and maintain Mr. Squire under it pending further proceedings. Further, Mr. Squire, you know who your probation officer is, right?
Yes, sir.
Do you already have a date set for your next appointment with
Yes.
that probation officer?
Yes.
When is it?
I'd have to look back at my phone.
I thought you'd just be able to reel that right off, Mr. Squire, since that's such an important date. Court will be ordering you to report as directed as a condition of your bond pending hearing.
Okay.
But I want to hear that date, Mr. Squire.
September 9th.
What time are you going to meet with your officer?
At 9:30.
Yeah, I hope that's the truth. So again, make sure you keep that appointment, Mr. Squire,
Yes, sir.
and follow your other probation conditions between now and time of court.
Okay.
All right. Do you have an attorney to represent you?
No, sir, I don't.
Can you afford one?
No, sir.
And Your Honor,
Yes.
for what it's worth, I am showing another Butler County case involving the same defendant that's set for a preliminary hearing next month. It would appear that Mr. Watts has been appointed in that manner.
Okay.
I am willing and able to take a UA to show that I'm clean. Anytime.
I am sure your probation officer will appreciate you volunteering for that when you see her.
Okay.
Okay. This is a misdemeanor case. Darren Patterson will be appointed. Mr. Patterson's appointed. Bond at $5,000 with hot rod's been approved. We have a court date with Judge Satterfield on September 12 at 2:30 p.m. And Mr. Squire has a September 9 appointment with his probation officer.
Right.
I think that's pretty well all the business we need to conduct here. Do you agree, Mr. Regier?
I would, Your Honor.
Any questions, Mr. Squire?
No, sir.
All right, keep those dates.
Okay.
If there's nothing further, then the James Squire matter will be in recess at this time. Mr. Regier, this would appear to conclude today's docket. Do you agree?
I do, Your Honor.
Very well.
That closes out another series of cases. We saw Hudson held without bond, High restricted to Kansas after 13 no-shows. Ingram learning a 4-year-old debt has ballooned into collections, and Squire juggling new charges while promising he's staying clean. Different charges, but the same theme: accountability versus opportunity. Judges constantly have to decide, should defendants be given another chance to fix their mistakes, or should the system come down harder to ensure
I do, Your Honor.
compliance?
Very well. Thank you. If there's nothing further. Yes.
Was that September 12th or September 19th?
Let me check. I hope I didn't misannounce. September 12th is my docket. That's incorrect. The correct docket would be before Judge Satterfield on September 19. September 19.
Thank you, Your Honor.
Thank you for that clarification. It's appreciated. I can conclude the docket then at this time. And the court is in recess.
With the criminal docket wrapped, the court shifts gears into something very different: a landlord-tenant dispute. Here we meet Sandy McKenzie, who claims his apartment has serious repair issues, from a cracked bathroom floor to a leaking ceiling that's now left a gaping hole. On the other side, the landlord's representatives insist contractors have been scheduled, but they say McKenzie hasn't always allowed access. What's about to unfold isn't just about unpaid rent. It's about whether basic living conditions meet legal standards and who's truly at fault when repairs remain unfinished.
So I understand that your short sides are nice side is court. So please make sure, even though they're nice shorts, it's still court. So you have to adjust a bit more professionally, okay? I understand. No, and still a lot to come in. Just you have to go back to court. So let's go on the record in the matter of residences on Pine for Sandy McKenzie, 501234.
Good afternoon, Your Honor. City Council, I'm April.
Okay, and Sandy McKenzie? Yeah. Okay, I need you to come over to the table over here, please. Okay, and your name for the record, please.
Sandy McKenzie.
Okay, yeah. All right. Okay, very good. And so today's date scheduled for an in-person hearing in this matter. And I know the two of you were able to have a conversation out in the lobby, correct?
In my little room.
Okay, sorry, out there, wait somewhere. And there's not a resolution?
Oh, there's not here.
Okay, so my notes show on July 25th that Mr. McKenzie indicated there were many repair issues. And then on August 11th, there was not an agreement on the amount owed, and that the plaintiff was still claiming $51.51. Okay? So, where are we on the repair issues? did you communicate those repair issues to your landlord?
Everything that I had, the issues that I had before, I also showed.
Okay, hold on. So the answer is yes. You communicate all that to the landlord.
Your Honor, yes.
And so, counsel, did you receive that from your client?
Yes, Your Honor, my client's scheduled Gold Star Restoration to come out there. They had a scheduled appointment with the defendant on August the 19th. They did show up and they were not granted access. Based on my discussions with Gold Star, they did knock on the door. They were not given access.
Okay. So let me ask a couple of things. There's a couple people here in the courtroom. Are these individuals
My clients.
to your clients? Okay. So let me do this. I'm going to have both here, you have the individuals, if you can please step out there with Mr. Katz, and I'm going to have all of your names placed on the record. Okay, and so, yep, your name for the record, please.
Sarah Ample,
Can you spell your first and last name?
ARIHAMBLIN.
All right, thank you. And what is your position?
Regional Manager.
Okay, and you have your name for the record, please.
Shala Haynes. It's Shala Haynes. SHALLAHAYMES.
Yeah, what is your position?
United.
Okay, I'm going to have two of you and Mr. McKenzie, all please raise your right hands. You solemnly swear or affirm testimony about to give this now be the truth, the whole truth, and nothing but the truth, Mr. McKenzie.
Yes.
Miss Hamlin.
Yes.
Miss Haynes.
Yes.
Okay. And okay, so counsel, I'm just going to ask a few questions to just kind of focus in what the issue is. What's that?
I'm good with us doing this.
Oh.
Sort of
informally, kind of. Okay. Your hair looks nice, by the way.
Usually, what? I'm sorry.
So your hair looks nice, by the way.
It looks better on Zoom.
Oh. All right. So, sir, what is it that you communicated were the repair issues that you were in need of?
I told them about the full, everything that's wrong.
Okay. So let me clarify something. I need specifics, and I'll tell you why I need specifics. Because number one, we have a record. And so all of that has to be on the record. Number two, people think because I sit in this position and have a role that I'm all knowing, but I know the least of all of you. So that's why I need you to tell me with specificity, not everything with the floor. I need specifics. Okay? So the floor. Tell me about the floor. Where in the apartment about the floor? So that's what I need. Okay? So before you're going into, the floor, the bathroom, or whatever, tell me, before you move on to the next one, tell me everything about the floor, okay? All right. And keep your volume up so that we can record here, okay?
Okay.
All right. So, the floor. You started with, let's go with the floor.
The floor in the bathroom is cracked, and there's a slope. It's directly in front of the toilet, and it goes into the tub.
Okay, so let me just want to pause you right there. What kind of flooring is it? Is it tile, hardwood, linoleum? What is it?
It's not wood, and it's not a tile. I don't know what it's called, but it's not wood and it's not tiles.
Is it linoleum?
I don't know what that is.
Okay, I'm going to defer to either Ms. Hamlin or Ms. Haynes. What type of flooring is in Mr. McKenzie's bathroom?
Oh, I have a video.
Okay.
I sent it.
What's that?
I sent it to you.
Okay. I can't. Okay. I appreciate that, but I can't look at anything unless it's properly before the court. So just for the record, I did not view a video because I can't yet review the video. Okay. The rules of evidence preclude me from reviewing the video just on my own.
Okay. I had to send it to, or their lawyers saw it too.
Oh, that's great. No, that's great. I'm glad that you both saw it. But just so you know that you emailed it to me, but I did not view it because I cannot view it unless it's done properly before the court. And foundation made and all that good stuff. So just so that everybody knows, I did not view the video. Okay. Not that you shouldn't have sent it to the court, right? Because yes, you had to send it to the court. But I'm letting you know that I did not view it. So when I tell you, breaking the myth that I'm all knowing, I'm 100% telling you I'm not all knowing. So what type of flooring is it?
Vinyl plank. It's LVP. LVP.
Oh, yes. Okay, LVP. That's vinyl plank. Okay. So it kind of looks like wood, but it's not wood, but it's more, yes, got it. Okay. All right. So it's cracked directly in front of the toilet.
So it's cracked. And when you're walking, say this was the floor, when you get to the crack, it dips down like you're going to fall through it. And it goes so far down that it goes underneath the shower.
Subflooring. So something with the subflooring potentially could be wrong.
I don't know what sub.
Well, so before you lay anything down, you have to have.
Oh, it's the floor before the floor.
Correct.
Oh, yeah. It like I said, it dips and goes underneath the tub. So much so that you can stick your hand under the tub.
Okay. So.
Or your fingers, not your whole hand.
Okay. So, you were made aware of that, correct?
This is where the dispute gets technical and very human. Mackenzie paints a vivid picture, a bathroom floor so compromised that he can literally slide his hand under the bathtub. To him, that's evidence of unsafe conditions, but the landlord's side pushes back, saying their records only mention lifting floor material, not a structural crack. This is a common tension in housing court. Tenants describe problems in lived experience, fear of falling through the floor, while landlords frame them as maintenance tickets with coded language. The judge's job? Cutting through the mismatch and deciding if the conditions justify Mackenzie's claims.
That's the gambling.
Yes, so we have a work order that was submitted.
Come on, sorry. So my question is, you were made aware of that?
Not the div.
Yeah. No, you're not made aware of the flooring issue in the bathroom?
It doesn't say cracked.
Okay.
I can tell you what was called in for the work order.
Well, hold on. So, you were not made aware of the crack. Were you made aware of a flooring issue in the bathroom?
It was called in that the bath floor was lifting.
Okay. So do you know there was something with the bathroom floor? Okay. All right. What's the next issue?
So on with the tub, when we first moved in, they told us that only thing needed to be done was the glazing.
Who's they?
It wasn't her, it was a different two ladies.
Okay, who's her?
Different two managers.
Okay, so as I stated before, I'm recording, I'm here.
I'm sorry.
And it's only audio, so specifics are important.
There were two different property manager ladies.
Okay, very nice. Okay, so you were told that the tub had to be glazed.
Yes, and we got there. It was all chipped up like old paint, on the inside the tub and around the top of the tub by the.
So the tub itself, the tub was chipped.
Yeah, inside of it. So the tub goes like slope, towards the drain,
right.
And from the back all the way, it was rust. Like a rust color, and it was just chips. So like it was paint or something.
Okay.
And then all through the bottom, right by the drain, it's paint chips. It chipped up like you could lift it up.
Okay.
And then you could
lift what up?
The chips. You can lift them off the.
Okay.
So there's right there where the faucets, or that's the end of the tub.
Okay. All right, so were you made aware of the chipping of the tub?
Yes, we were, and it has been glazed.
Okay.
So our contractor was told out this week.
Okay, so what about the chips in the tub? That doesn't just get fixed with glazing.
So when they prep for the glazing, it'll smooth it out and cover everything over with the glazing.
Okay, so that hasn't been fixed yet.
It has been done.
Oh, now it's been done.
The tub was
You told me it was glazed.
The tub was glazed.
Did they address the chips?
The chips that were in the thing. I don't know if she got them from the hole that was in the ceiling that fell into the tub, But the ones that were in the tub, they're not there anymore. That's what you mean.
Is the chipped paint repaired?
Inside the tub, yes.
Wherever the chipped paint was, is it repaired?
Yes. And
All the paint that was chipped on the top was repaired.
yes.
Okay. All right. When did that occur?
So that just happened. If I could add, every time that
No additions right now. When was that repaired?
the last time that we had a
July 20, August 11th?
yes,
Was that the same day?
no, the last time that we had that video chat, they scheduled it for that time, and I remember telling you that they scheduled it for today, but I was with you, so I told them they couldn't come, and then they came the next day.
Okay, so the 12th.
Yes.
August 12th. Okay.
Now that was the third time.
Okay, hold on. Nothing additional right now. What's the next issue for here?
Okay, so
Start talking about something with the faucet.
yes, so the faucets in the tub, it has 3 handles, obviously one for cold, hot, and then one for the shower. So all of those, when you turn them on, you expect, like, if you turn on cold water, it should just be cold water. But when you turn the cold water on, the cold water comes out of the faucet and the shower. And then when you turn it off, both faucets go off. Then we turn on the hot water, both come on. So you can't turn on the shower and just have a shower. The faucet in the tub constantly runs. It never turns off. So when you turn on and take a shower, the tub is filling up the whole time, which made it difficult before they come to glaze the tub.
Okay, has that been repaired?
No.
Okay, were you notified of the shower issue, shower tub issue?
Maintenance did advise that there was no leak when they went over. No leak.
No leak when they went over. So they looked at it. Kind of like when your car doesn't work, you take it to the shop and then it works that day. Okay. Hold on, just a moment. Okay, did you have video of that also?
So
I presume you did. Okay.
I will say that's not the leak. The leak is above that.
Well, hold on. Okay. So when you say that there's no leak coming out of the bottom faucet and the shower head at the same time?
That wasn't specified on the maintenance notes. It just said ceiling is not leaking.
Okay. So down about the faucet.
Okay. They haven't made any
The
notes.
shower head and the tub faucet.
I'm sorry. Yeah.
Okay.
So they haven't made any notes on the faucets.
So you don't know if maintenance has looked at that yet?
I personally don't.
Okay. Ms. Haynes, has maintenance looked at that?
Nothing.
And Your Honor, it's not maintenance that's going to be doing all this. It is Gold Star that's going to be going in there.
Well, that's fine. Somebody has to find out. I presume that they're sending maintenance in there first to look at something before they go to dispatch out to repair.
Well, I think we're going to have Gold Star review everything that was outstanding so that they can confirm that everything is working properly. If they're already out there, they would be looking at everything.
They do plumbing too?
Well, they would be able to, yeah. I mean, they do have.
Oh, kind of a jack of all trades, master.
I mean, they're a restoration company, so they have
contract
expertise.
Okay. All right. All right. So let's jump to the ceiling.
Okay.
That's in the bathroom also?
Yep. Directly above the shower.
I'm sorry. You only have one bathroom?
You only have one bathroom.
Okay.
So directly above the shower, when we first got there, it was like a crack, and you could see that the paint was starting to come off, which was probably some of the paint that was in there, also the chips.
In there?
In the tub. Sorry, in the tub where the chips were.
Okay.
So right above the shower. So here's the shower head, and then here's the ceiling, and the hole is right there. So, as it started to get worse, I didn't know what was happening because you could hear it dripping, but I don't know where it was coming from. Plus, we had just moved in. So,
I'm sorry, what floor do you live on?
We live on the second floor.
Okay, there's 3 floors.
3 floors.
Okay.
And so I was listening to trying to find out where the leak was coming from, and I never found it, but you could always hear it. And you could hear it hitting you know how a tub sounds.
Yeah.
So I thought it was the sink. Wasn't the sink. Then I went to the sink in the bathroom. Wasn't that sink. So I couldn't find it. So one day, taking a shower, got out of the shower, and it just starts coming down like the shower was still on. So I tried to turn the handles, but it wasn't the shower. It was coming from the hole.
Did you take a video of that?
Yes, I have not when it was raining a bunch because I had to go. I was getting out of the shower. And I wasn't dressed, so I had to go get that. And I took a picture, and I have video, and I could hear that upstairs they were doing something. I don't know if it was the tub or the toilet, but you could hear something running.
So when you say they were doing something, was the apartment above occupied?
The apartment above us is occupied. There's been somebody there since we have been. There's always.
So when it started gushing out of the ceiling, was there a hole or was it just?
No, there's a hole.
There was a hole.
It got big.
Open up.
As the time has gone on, it went from just probably about as long as my finger to now you can fit like 4 fingers in it.
Okay.
It's
So Miss Hamlin, obviously, she's already testified that there was no leak at that time. Did they note if there was a hole above the ceiling?
No notes, but we have had the Gold Star contractor scheduled a few times. They've come out and they've not been able to gain entrance in the apartment.
That's when he's stubborn. So he's just answering my questions. The notified maintenance indicated no leak, but was there a note about the condition of the ceiling above the shower where Mr. McKenzie is indicating there's a leak?
So that would be the reason why we would call contracts out to make drywall repairs.
So the answer is yes. You're aware that there's damage to the ceiling?
There. Yeah, yes, that's why we would call a contractor out.
I know it sounds very annoying in the questions, but I need to make a record.
I understand.
So I need to be very clear on the items. Okay. All right. So out of the ceiling, what's next?
So after the ceiling, you can see now that I know where leaks come from, I noticed it a lot more, and I could see that it started to run down the wall. So sometimes it just
still in the bathroom.
Still in the bathroom.
Okay.
Everything's in the bathroom.
So I'm sorry. So all the issues, the maintenance issues, are all
except for one.
Okay.
But it comes from the bath.
Okay.
So, as the hole got bigger, it started to not just fall like rain. It started to go against the wall. So it would be falling, and then the water would go against the wall and go all the way down the wall.
Okay.
And then that's where you had that long, water line from the hole.
Okay. So what is that also in the bathroom?
Yeah, everything in the bathroom.
So has the wall, has there been a split in the wall?
The wall where it was leaking down?
Yes. Okay.
But it's a line of water, like a brown line from the water going down into the tub. And that's on the video too.
Okay. So is the bathtub, is the entirety of the bathtub ceramic? Is it a ceramic?
The case circles around serious questions of habitability, a leaking ceiling, water lines running down walls, and disputes over whether contractors ever gained access to fix them. For tenants, it's about dignity and safety in their home. For landlords, it's about protecting property and ensuring cooperation so repairs can actually happen. And for the judge, it's about finding the truth in the middle of conflicting stories. Housing cases like this remind us, justice isn't always about crime. It's about the places we live every day.
Is it a ceramic surround, so to speak? Or is only the base of the tub ceramic and the rest of it is painted?
No, I believe it's the same. It feels the same.
So the walls are the same as the tub?
Oh, no. The tub, like the side of the tub and the inside. That's what I thought you meant. I'm sorry. The wall have little squares.
Okay. All right. Okay. So, safe to presume that restorations want to look at that as well.
It's probably all related.
Big deduction. Okay,
Maintenance guy.
or detective. Okay, and so then what's the next issue?
So, the next issue is that someone had come, there's only been a maintenance coming to our house 3 times. Like actually last time.
Hold on. I want to know what's the next issue that needs repair.
That's so the next issue is that, they told me when they came in,
Who's they?
the manager people.
Miss Hamlin and Miss Haynes are two different. Sorry, okay.
This is the first time I think this person is new.
Okay.
So, they had come
She's
in.
not new. She's new to you. But
New to, you know, she had, the guy had come in, saw the hole after we told him about it. And then he come in to fix it and said, he, you know, stuck his hand in there. And then he said, I have to go upstairs to fix that. And he left and he went upstairs, but he never came back.
Okay.
And so the leak now is not just dripping there, but it went to the other side of the bathroom. So
different from the wall, a different spot too?
So what do you mean like the wall?
Well, you just testified about it dripping down the wall, so
Yes.
now it's across the whole ceiling.
Yes.
Okay.
So if when you walk into my bathroom, you walk in this way, the
The McKenzie
shower.
housing case continues, and the problems just keep multiplying. What started as one hole in the bathroom ceiling has now spread. Water leaks across the ceiling, down walls, through a light fixture, and even onto appliances. McKenzie says his washer and dryer were damaged, while the landlord's side insists repairs have been scheduled, but blame miscommunication for delays. This part of the hearing dives into the heart of landlord-tenant disputes. When repairs drag on, who's responsible for safety, damages, and missed appointments?
The shower and the tub is to your left. So you turn and you go and you're looking directly at the shower. And here's the head of the shower. There's the hole. And now the leak is gone all the way across to the other side, to the entrance where you walk into the bathroom.
Okay.
And so as it's going across, you can start to see it in the video from one video to the next. It's getting darker and darker and darker because it's water. And then it stopped and it turned into like a circle right in the middle of the ceiling. And now the paint has started to chip and now it's opening up just like the other hole. It hasn't opened up, but it's got a hole. It's brown.
Have you touched it up there?
No, I don't reach up there.
Does it feel cold or damp?
It leaks, but I haven't touched it. But I see the water and it's also above target.
Okay. So then tell me, so anything else in the bathroom? Any other issues in the bathroom?
So going across the ceiling to the other side of the entrance is the leak. And now it went to on top of our washer and dryer. The washer and dryer is inside the bathroom. So when you walk into the bathroom, you're looking directly at the washer and dryer.
Okay.
And just above the washer and dryer is a light. And it has what would you call that? A fixture, a bulb. It covers up the bulb. And it got darker and darker and darker. Then it turned brown. And then it started leaking through the light socket. So I immediately called down to the manager's office when we realized that the leak, where there's water coming from somewhere. I thought it was coming from the other leak, splashing, because it was going onto the floor. And I'm walking on it, and I'm like, well, it's not going all the way across
This
the
detail
floor.
is especially alarming. Water leaking directly through an electrical light socket above the washer and dryer. McKenzie testifies he immediately called the landlord's office after seeing water drip through the fixture. From a tenant's perspective, that's a dangerous safety hazard. Electricity and water don't mix. But the landlord's attorney pushes back, asking whether notice was properly given and whether access was refused. This clash shows how differently each side frames the issue. To the tenant, it's an urgent safety crisis. To the landlord, it's a scheduling and communication.
Going all the way across the floor. Again, there's another leak, so now I'm trying to find it. No, it's not the one in the tub. And I'm trying to hear it, and then you hear it hitting my tub.
So I'm sorry. So has there been damage to your washer and dryer?
Yes. So
Okay.
that,
You submit that to,
yes,
okay. And so Ms. Hamlin or Ms. Haynes, do you have information about that? Yeah. Who'd you submit that to?
the other lady.
Okay.
Other lady manager, sorry.
Okay, so let's leave the bathroom now. Is there anything else in the bathroom?
Yes, there is.
There is?
There is a lot in the bathroom. When I tell you,
Okay, so let's leave the bathroom for a moment.
Okay.
And tell me where else, you said there was everything but one is in the
Yes.
bathroom. So where's the one that's not in the bathroom?
So directly next to our bathroom is our kitchen. So you have the washer and dryer, which is stacked on top of each other. And then there's a wall, and then there's my kitchen.
Okay.
And the ceiling has started to rot. There's a black mold or mildew or something up there. And it's going, so say this is our floor, it's going onto the kitchen, and it's in a crack of the kitchen, and then it started to leak, and it was small, but now it's getting bigger and bigger, just like the other cracks and leaks. Also,
Okay, are you aware of that?
No, ma'am.
I let them know.
Okay, how have you been letting them know, sir?
I called down there to speak to them on the phone, because if I don't call them, I'll send an email, and I have those emails. I sent those to you as well. Sorry, I know you didn't get them yet. Okay. But I called there and I told them that for a bit, our sink and dishwasher was messed up, but that fixed, and nobody came to fix it. The maintenance guy came in, the maintenance guy came to the door, and he never came in, and he told my daughter that we have to get parts for that, but it won't be for another month until the parts come. He never looked at it.
So let me just ask you this question, sir.
Oh.
So where have you been depositing the money for rent?
We have an escrow account.
Okay, and Mr. Getz, please, are you, has Mr. McKenzie provided you with a proof of that?
No, I haven't received anything. Okay.
I've never even talked to this guy before. Nobody's ever asked.
Okay, well, he's the attorney for your landlord.
It's been
Mr. Morgan was at the first hearing. He indicated in his notes that Mr. McKenzie was putting money in escrow, but he's taking his word for it. He didn't provide him any.
Okay, so you have it in a bank account?
I do have it in a bank account.
Okay, so okay, so Gold Restoration. Okay. They indicated they went there on Tuesday?
Tuesday. It was scheduled to be there on Tuesday.
Okay, so were you involved in the scheduling of that?
No, I was not, and nobody came to the house. I got a call. Now, I don't know when the new lady came, but I got a call on the phone saying, are you available for them to come in and fix the hole above your shower?
Okay, when did you receive the call?
I can't remember the day.
Was it the day off?
Yeah, it was that day. They was asking, can they come the day when they
That same day?
Yeah.
Okay.
And she said, I said, no, I'm not there. And she said, there. I said, how come you guys didn't call and schedule it?
Okay, so you weren't home? Okay,
No.
so Miss Eight, is that how that went down?
So I may just.
Yes or no? Did you contact Mr. McKenzie?
Yes.
The day of the restoration company coming out to the property?
Yes, I talked to them after the restoration company was there trying to get in.
Was there any notice given to
Yes.
Was there any notice given to Mr. McKenzie about the day and time that the restoration company was going to be there?
You're all right to answer that one because this wasn't from the proceedings. I spoke to Kenora, who used to be the manager there. She indicated that she did call prior to the scheduled time.
When did you call?
She said, a for sure date beforehand.
Okay,
I
well,
asked for the specifics as far as how far beforehand, but it was confirmed that they were aware of that scheduled appointment.
are we talking about the one for Tuesday?
Correct, and it was not on Tuesday. There was no.
You said the 19th. That was Tuesday.
Was the day that they were there.
That's the date we're talking about.
Prior to that date, she called Mrs. McKenzie.
That's the date we're talking about,
I
right?
understand that, but you asked me if they were aware beforehand of the scheduled date. So what I'm saying is that she did call him before that date to inform him that Gold Star was going to be here.
Okay, so where's Miss Kenora?
She's available via Zoom, Your Honor. I only after speaking to Ms. McKenzie did I contact her to find out, because my understanding, speaking to everyone, looking at the information, was that they were aware of the situation. When he informed me that, one, that they were unaware of it beforehand, and two, no one was there, I contacted Gold Star to get their information, as well as I spoke to Kenora to find out what she recalls from this.
Okay, so she doesn't work there anymore?
No, she's in a different site.
Okay, when did she move to a different site?
Tuesday was the official transfer.
Oh, okay. So here's what I'm seeing, right? I'm seeing, and that seems there are a lot of water issues that need to be addressed. And so, and I also see that there is, like we said, miscommunication somewhere regarding fixtures or fixing or renovating, whatever it may be. Here's what I'm going to do. I'm going to set this over for a few weeks so that work, well, at least the restoration company can come in, see what has to be done. The restoration company isn't going to come out the day of without any notice to anybody at the property. So I think what would be best is if the company provides Mr. McKenzie's email or phone number and then includes Mr. McKenzie on that thread with the restoration company, so then there's not any question as to when somebody is coming to the property. Also, sir, I know you have a separate bank account. So what I'm going to do is I'm going to order that you share that information with Mr. Cass. Mr. Cass, if you're comfortable with that, and that money continues to be deposited, then we don't have to do an order of escrow here at the court. You have to continue to deposit that your rental money in the escrow account. Okay. Now, what happens with that money is what I'll determine when everybody comes back after there's been a determination as to what has to happen.
I had to call the city of Riverview building inspector to come in, and they came out and they started inspecting all the buildings they are about. I don't know what
that's something sound.
Well, the only reason I say that is because the water that was above the washer and dryer started to mold and went down into the wall next
to, which is going to be some expensive repair that has to occur.
It came out of the light socket. And there was a bubble underneath the light.
Okay.
And water squirted out of the light socket.
I'm not discounting any of the stuff that you're telling me, right? I'm not. What I'm finding is that there's a large issue that has to be rectified in the bathroom that seems to now be making its way through other parts of the apartment. So, and then depending on all that, is there any sort of abatement that you would be entitled to or not? I don't know. But I think the goal is to make sure that the rent's being deposited and that the apartment is repaired.
The rent is being deposited. I gotta be honest, I really don't want to. I've been looking for a new.
Oh, I understand.
If that's the case, maybe we could create this as a termination tenancy, because in all honesty, I spoke to Gold Star. It appeared that there was someone in the apartment at the time who indicates his brother and his daughter lived there. I think that they were not given access to the apartment, and this is not for second.
Well, okay. That's all. Stop. I'm not going to get back and forth as to whether somebody was home, not home, right? What I'm stating is that there's clearly something that has to be repaired. If there's rent that's being deposited, so that portion of the statute being complied with. Mr. McKenzie's indicated that he is looking for somewhere else to live. Okay, so maybe there is some communication between council and Mr. McKenzie as to what that looks like moving forward. So I'm not going to order that he has to move out by a certain time.
I'll see if I can discuss that with him and see if we can come to an agreement to convert this determination if he moves out by a certain date.
Well, he also has to make sure he's able to locate someplace by a certain date. And so perhaps he wasn't prepared to do that, but now there's all these issues that have not been rectified. So let's have everybody come back.
No.
Hold on. We can do. So 3 weeks from today is September 12th. So there's not a docket that day. So we can do Tuesday, September 16th. I'm wrong. I have a training that day. We could do we can do Monday the 15th, we can do 11 a.m.
Sure.
Yeah.
Okay.
We haven't resolved that.
It has to be the 15th. When you're like 8.
Well, Wednesdays and Thursdays are awful days. You thought you had to wait today? You'll be waiting hours on those days. For real. Do Mondays not work?
If it on any other day would be great.
Is there something significant about the 15th or is it Mondays? It's
Mondays.
Well, here's the thing. So,
well, what time is that?
I was going to do 11 a.m. Do you work on Mondays?
What? 2.
Okay, what hours do you work?
I go from like 6 in the morning to like 10, 12.
Okay. Well, here's
I wouldn't make no fuss about it, but that's like a big money day.
Well, I can have you all up here via Zoom if there's a resolution. The reason I had you all in person was so that all of the documents could be exchanged. Everybody could look at everything right then, and there couldn't be anybody saying, "Oh, I didn't get this, I didn't get that."
There's a from what he was talking about the call where they kept saying somebody was.
No, I'm not getting into that.
No.
Not doing it.
Okay.
Not getting into that.
Forget that part.
I'm not.
Made an arrangement for today.
What I'm going, listen, I've already indicated that you are to be included in any communication with the restoration company so that there could be an agreed upon date with everybody and that you are in the know.
Absolutely. I'm the one who was on the phone and rescheduled that day for today. Every time that we make an arrangement, it's always on court days for some reason. They only come out and to my house and actually do anything.
Okay, I'm going to guess that that's a coincidence.
Every time.
Well, I don't know. I don't know because I don't know. I'm going to hope that is a coincidence. Okay, so
they're there to fix the hole in the ceiling, Your Honor, but they still haven't fixed the leak. So why would you fix the hole if there's still a leak?
Well, according to Mr. Cass, Gold Star is they do all of it, so they're going to know who they have to call for a leak. Because obviously, if there's damage to the drywall from moisture, there is a leak.
So there's mildew or mold or something.
Yes, so all of that's going to have to be remediated.
And that's what they do, Your Honor.
The people that came was I don't know who goes.
Okay, hold on. Well, I'm not going backwards right now, right? I'm not going to, I'm not going to go into who came or who didn't came or come to the property because you're all coming back on the 15th. Gold Star will be there.
This will be the first time.
Well, what time are they scheduled for today?
At Gold Star.
What time are they scheduled for today?
There's a maintenance guy.
The question is, what time are they scheduled for today?
11 o'clock today.
Same time?
Every single time.
Well, that was probably between him and Gold Star.
So did that get communicated about that to Gold Star? Yes.
I thought Gold Star involved you and we made the appointment together. You said Friday. You said today. This is the day we go to court.
I said, are you sure you want to do that today? Because we have court that day. I have court with you guys that day. Did I not say that?
And I said, is that the date that you want? And you said yes.
And you said if I break that appointment,
I said it's hard.
Hold on, only one can speak at a time.
if I was to break the appointment, she said, if you cancel again, I said, I didn't cancel the first time. You called me out of the blue.
Okay, if you cancel again, then what?
Then she doesn't know when they'll be able to come out and fix it.
And I would have to reschedule another time.
Okay, but I really don't know why you would have even picked today at 11 a.m. when today was the date for court. When Gold Star gave you the date and time, today at 11 a.m., why you didn't just tell them that's not a good date?
They didn't say that. They actually said Thursday. He said, well, let's do it Friday. I got court with you guys on Friday. I said, you want to do
one at a time, so please stop.
He said, I said, you want to do it that day? He said, I said, what time is court? He said 11. I said, you think you're going to be done with court by 12? He said, yeah. So I scheduled it.
Okay, so there's not going to be any more of this going on because it's all going to be done via text or email between Mr. McKenzie, the management office, and the restoration company or the plumber, whoever else has to come out. Anytime somebody has to go into the apartment and there has to be communication, it's to be via text or email. So that way, all the he said, she said is gone. Gone. So everybody will be back September 15th at 11 a.m.
And Your Honor, as far as the escrow, the amount that's in escrow, is that going to be provided to me?
Yes, Mr. McKenzie has to submit proof of the balance of the rent in the account.
Okay, I will submit proof. That's no problem. But the another problem that we had with the other management team is that they tried to charge me for the washer and dryer and said they were going to include that in the rent.
Hold on. What is your monthly rent?
$1,499. $1,499 is the base. $118 is utilities. There's $14 of damage waiver. So the monthly rent totals. So $1,629 would be the with including the utilities and the waiver. So $1,629.
So is that you right? So $1,629.
I don't think that. I think it's 115. I mean, it's 1,559. I believe.
It's $118 in utility charges per month, which includes water, gas, trash, pest control.
It's just water.
By the end, the judge orders more oversight. Repairs must be scheduled with clear written communication between all parties. Proof of Mackenzie's rent deposits must be shared, and the case will return in September. At stake is more than just repairs. It's whether Mackenzie stays in the apartment or transitions out under a negotiated termination. For tenants, this case highlights how hard it can be to live with ongoing repairs while still paying rent. For landlords, it shows the challenge of balancing access, scheduling, and property upkeep.
There's utility.
Yes, I pay my own.
There's utility in there.
Okay, so we don't even have an agreed upon rent amount?
I have it at home on my sheet. Okay. I don't know what. I don't think he knows.
Well, I'm just the attorney that represents him, so I'm pretty sure he knows.
And I have a company signed lease here.
Good. What does the signed lease say?
$1,499 is base rent. Utilities are as follows: $60 water, $45 gas, $10 trash, $3 pest. So that right there totals
$16.17. I would have lost your time.
Okay, plus $14 for the damage waiver, which is another addendum in the lease, which is
1631 is the total.
I didn't even know about that.
Okay, so 1631 is the total. When's the last time you paid rent, sir?
When we first got there.
he has a credit going to June, $37. So
Okay, so we're talking July.
June, July, and August.
June, July, and August, less than credit. Okay. So that should be 48.93. 200 and how much dollar credit?
There was 237 as of June 1st going into the month.
So 46.56 should be the amount in escrow. Okay, now I understand, sir, that you are questioning whether or not that is your rent. So even if it's something around that amount, the court would be satisfied until there's some resolution as to what that monthly rental amount is. So you need to submit proof of that to Mr. Katz by Wednesday, the 27th.
And Your Honor, with that, would he provide the activity statement showing that he has been placing money in escrow, or you only care about the date of the placement? Because he's been saying he's been putting money in escrow. At times I do like to see that they actually have been.
Yes, activity statement as well. Okay. And then we'll see you all back on September 15th at 11 a.m. Okay?
And Your Honor, do we want to maybe discuss a time period to schedule a bolster?
Well,
we're
given that
we know it's not 15th of September.
That's correct. And I'm going to expect that that's something that's going to be done relatively quickly, since the leak seems to be spreading and there seems to be dark areas that need to be addressed. So what I'm going to do is I'm going to go off the record. I'm going to allow you all to go out in the lobby, because I have 6 in custody that I'm going to next. Allow you all to walk in the lobby to discuss that. Well, I'm going to expect that would be something that's going to be on the calendar by one day next week.
Okay, so let me do this, because if he runs home now, they might still, because it was between 12 and 5, I believe. So he might still be able to catch some today. If they can get out there today and take care of it, that would be great, because I'm assuming they have to take an initial assessment, and then they have to come back and schedule a time where they actually do the full work.
Possibly. Okay. And there may have to be multiple times. You have plumbing, you have drywall, you have...
So I'm gonna give him my phone number, and he can reach out to me if he doesn't reach them today, because if they come out today, that's great. They at least start the process. But let me give him my contact information, and this way he can reach out to me and say they haven't been here, or they have been here, and then we can work on the next step.
Okay. So, sir, you're going home. You're going to wait. You're going to see if they've been there, or if they're going to show up. You're going to communicate to Mr. Katz.
I don't want to find out. They're going to, because they haven't been.
Well, it wasn't done.
Between 12 and 5, they're going to be there. So if he gets to his house now, because they don't.
12 and 5. I'm just saying they were supposed to have been there at 11.
What time?
You made the appointment for 12 to 5 today. I was scheduled from 12 to 5.
That wasn't stated. That was not stated at all. No, stop. We're not arguing with me. Well, that was me, 12 o'clock. Nobody said anything about 12 to 5. So, you have the number right in the names for Gold Sun.
Yes, ma'am.
Then we have to step out in the lobby. Find out if they've been dispatched to the apartment yet. Okay? If they have been, see if they can go back. If they have not, good. Then you know you're going to go and you're going to wait for them to be there. And then any other subsequent scheduling needs to include Mr. McKenzie. Okay.
Thank you.
Thank you. Let's go off record.
Have a good weekend.
Thank you as well. What's that?
They said 11. Same time.
Sir, I'm done. I'm not arguing. Nobody's arguing anymore. There's been a miscommunication, whether it was 11 o'clock, 12 o'clock, 12 to 5, whatever it is. Now this is what we're doing moving forward. Yes, I'm very much aware as to what was said. Yes.
Your Honor, this is Daniel Schmitz.
All right. Oh, they're right here. All right, thank you. We are on the record in the matter of the city of Wyandotte versus Daniel Schmitz, 251229.
Your Honor, good afternoon. Richard T. Serrano, P33828. Today I appear as MIDC
The
counsel.
Mackenzie housing dispute turns to numbers, and they don't add up. The landlord side says the lease sets rent at $1,499 plus utilities, bringing the total to $1,631. Mackenzie pushes back, insisting he never agreed to certain charges. What seems like simple math becomes another battleground. Base rent, fees, credits, escrow payments, all of it under scrutiny. These details matter, because if rent in escrow doesn't match what's owed, a tenant can lose critical protections.
Today I appear as MIDC counsel on behalf and with my client. Mr. Schmitz is presently in custody. And Your Honor, today I've had the opportunity to explain to him the nature of the charges he has pending, all of his maximum penalties, and all of his constitutional rights. He understands both. Thereby today we waive formal reading, stand mute, ask for a plea of not guilty to be entered. Sir, please state your name.
Daniel Schmitz.
All right, thank you. And so the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. Schedule this matter for pre-trial on September 3rd at 10:15 a.m. Counsel asked to bond.
Your Honor, my client tells me that he's age 39, presently engaged. He just had a hip replacement, Your Honor, thereby he's been unable to work. He does work full-time for a heating and cooling company. He has that job waiting for him when he's fully recovered. He tells me he is on probation in 2 counties, Oakland and Wayne County. He's doing well. He's never failed to appear in court, he tells me, and he's current. He has no bench warrants, he believes. I'm sorry, he has 2 bench warrants, he believes, in Lincoln Park and Dearborn, both minor misdemeanor matters. One is probation violation in Dearborn. One is a traffic misdemeanor in Lincoln Park. Other than that, Your Honor, we would hope the court would see fit, since it's under a doctor's care, and presently has never failed to appear in court except the ones where he has bench warrants, of course. But currently he is taking care of his probationary matters. We ask for a personal bond, or bond he can reasonably expect to post, Your Honor. Thank you.
Okay, so sir, when did you have your hip surgery?
About 3 months ago.
Okay. And you not have you come back to work yet?
I'm just about to go back to work.
Well, what does that mean? You're starting tomorrow or today?
I was supposed to start next week.
Okay. All right. And so what are you on probation for out of 6th Circuit Court in Oakland County?
Fentanyl, Your Honor.
And what about out of 3rd Circuit Court in Wayne County?
That was disorderly conduct, Your Honor.
It was felony matter reduced to a misdemeanor?
Yes, Your Honor.
Okay. And what about the matter from Allen Park in the 24th District Court for retail fraud from February of 24? You got information on that matter?
No, I have been time served.
Okay, that was from the matter that was also January of 24 as well?
Yes, Your Honor.
All right, and your matter that you have a warrant for your arrest on 23 in the 19th District Court, that was possession charges, is that correct?
Yes, Your Honor.
And what are your charges here, sir? Possession?
Possession, Your Honor.
If you're in a test right now, sir, what is in your system?
What was that, Your Honor? Sorry.
If you were to test right now, what is in your system?
I'm guilty.
What would you test for?
Oh, I would test for the medicine that I'm prescribed, Your Honor. Suboxone.
Anything else?
I would probably test for Adderall. Probably 2 weeks ago, I did take an Adderall that I found when I was cleaning out my house.
All right. And you don't have a, well, okay, anything else?
No, Your Honor.
And you looked at, and, all right, well, here's the question. You have two, warrants, one of which is for, matter with a possession charge. You can currently have probation out of 2 circuit courts, one of which is for possession charge. So
Here, the judge takes control, frustrated by back and forth arguments about appointment times. She orders Mackenzie and the landlord's team to step outside, confirm whether contractors have been dispatched, and ensure repairs actually begin that day. This moment shows a key part of a housing judge's role, not just deciding cases, but actively managing communication breakdowns. With leaks spreading and structural concerns growing, the judge makes it clear, repairs can't wait.
So the court wants to ensure so that you're going to appear in court because you don't seem to appear in court very well. So the court's going to order a $10,000, 10% bond. You're not to consume the alcohol or drugs unless prescribed.
What was that?
You're not supposed to consume the alcohol or drugs unless they are prescribed. And you are not to release GPS however to the Wayne County Jail.
Well, not to be.
Correct. If it goes by, you have to have a toilet before you release.
Okay, Donna.
All right, thank you. Have a good day. Is this reaching down?
Yes, ma'am.
All right, we're on the record of the matter of the city of Wyandotte for Slingman Arrow. 251-230 A and B, 24244. Cancel your appearance, please.
Your Honor, good afternoon. Richard T. Serrano, P33828, appearing on behalf with my client presently in custody. Today, Your Honor, I've had an opportunity to explain to him the nature of the charge against him. He understands all matters pending, and he would waive formal reading, ask for a plea of not guilty to be entered.
The court. Answer your name for the record, please.
Lee Madera.
All right. And so the court will waive the formal reading, enter plea of not guilty for purpose of the arraignment. Schedule these matters for September 3rd at 10:45 a.m. Hearing counsel, yes, 2 minutes.
Your Honor, Esteban, my client tells me he is 44 years old. He has some criminal history the court can see before it. These are not similar to any of the things that he's had in the past. These matters pending are really minor compared to those. He's single, but he supports 3 minor children. He is working for his own construction company, so self-employed. And he does have some bench warrants out of Allen Park, he tells me, and Van Buren, and one in Canton. Your Honor, if he's released, he said that he will take care of those matters as well as appear in court. So we ask the court's discretion in setting a bond. He can reasonably expect to post, if not a personal bond. Thank you.
All right, so sir, you've blown all the courts off and you haven't gone in to take care of them. And now all of a sudden you're going to take care of them if you're released. Is that what you want me to believe?
Well, no, man, I've been taking care of them. I just got to leave part done. I've been doing them one at a time for financial reasons. I just got to leave part done, secure legal part, and then next week was going to be Wyandotte. And I'm trying to do it one at a time. I can't take care of all of them all at once. I'm trying my best to take care of the kids and in this.
Sir, if you're going to test right now, let's see your system.
Okay, no excuses, sorry, ma'am.
What?
No excuses, ma'am. I should have been taking it. I should be more responsible.
If you were to test right now, what would be detected in your system?
Oh, just cocaine. Sorry.
Just cocaine. No big deal, just cocaine.
Oh, no, I'm just saying cocaine.
And are you not going to share for anywhere, so?
No, ma'am.
What happened with your matter in Lincoln Park, the felony drugs from November 23? What happened with that matter?
I'm supposed to I'm doing the go back every month for what they call the payment reviews. payment reviews.
Oh. All right, and then also Lincoln Park from November 23, there's an assault or your release on prosecution. Felony assault April 24. And then
Those are all dropped. Those are all dropped. Those are all taken down, those are all dismissed. Right.
all right, well, sir, I have to tell you. Where is it you work?
Construction company. For myself, my uncle, me and my uncle both run a construction company.
You and your uncle?
Oh, I don't run it. I just help him. I help him maintain it. Let's just say.
All right, well, sir, you have multiple warrants. You failed to appear even in this court back in 2024. And so the court really wants to make sure you're going to be appearing in court. And for your own safety as well, sir, as the safety of the community, the court's going to order, in each matter, the court's going to order $7,500 10% bond. You are not to possess or consume any alcohol or drugs unless prescribed.
Ma'am, is there any way to do a personal bond with the tether so I can continue to work to help the kids? And get my car out. My car was impounded as well.
Sir? No. No.
Okay.
No. You were to post $7,500, 10% on each case. And I will see you
That's
back
1,500, right?
on the 30th. Yes. On the 3rd. Yes.
See me.
That's the record.
Okay, cool.
Thank you, Your Honor. I believe that's all I have.
All right. Thank you. Have a good day.
Thank you to the court as well.
With Mackenzie's case set for follow-up, the docket shifts back to criminal arraignments. But his hearing leaves lasting questions. How precise must tenants be about rent and escrow payments? How much responsibility do landlords bear for urgent repairs? And what happens when both sides are convinced the other isn't cooperating? These cases remind us, housing court isn't just about contracts, it's about people trying to live safely in their homes. What do you think? Should judges step in more forcefully to enforce repairs? Or is it fair to balance responsibility between both sides? Drop your thoughts in the comments, like the video, and subscribe for more courtroom breakdowns.